Well, good afternoon. Thank you for having me. Mark asked me to talk about issues that come up from time to time in an election year. Election year is kind of a misnomer for us because every year is an election year for us. We have our city and school board elections in odd years, and then in even years, our legislative, statewide, and county races. Also, a ballot issue could be done at any time, and we'll be talking about those to some extent today as well. So before I get going, I'd like to make sure that everyone here knows about the Ethics and Campaign Disclosure Board. We're the second smallest agency in state government. The smallest is the Public Information Board. Both of these boards are independent, and we're proud of our independence. We're independent from the governor's office, and I'm one of the few directors in state government that is not appointed by the governor. I'm appointed and serve at the pleasure of our board. And of course, that's by design because we oversee the governor's campaign finance activities as well as ethics issues involving the executive branch. Our responsibility is really limited to two areas. Chapter 68A, which is campaign finance, and Chapter 68B of the Iowa Code, which is government ethics. I'd also like to talk just briefly about how we interact with different levels of government. So for state government, we only have jurisdiction over the executive branch when it comes to government ethics. Chapter 68B of the Iowa Code also applies to the legislative branch, but that is enforced by the House and Senate ethics committees. Chapter 68B also applies to county and local officials and employees to some extent, primarily gift law and conflicts of interest, and that is enforced by the county attorney instead of us. We do have advisory authority that we can provide informal and formal advice to counties and local jurisdictions, and we're happy to do that. I take a lot of phone calls from city attorneys, school board attorneys, government officials and employees, and we also can issue advisory opinions that, if followed, constitute a defense to any allegation of unethical conduct. Interestingly, Chapter 68B also has a provision at the end that requires the Supreme Court to promulgate rules to create a code of ethics for its employees and officials that's similar to Chapter 68B. So we have nothing to do with the judicial branch as far as ethics. Now, when it comes to Chapter 68A, which is campaign finance, we do have jurisdiction over any candidate for state or local office. We have jurisdiction over all the state and county party activities, as well as the PACs. Judges standing for retention are considered candidates. We've never had a judge run a campaign, but in the event that we did so, that judge would be under the same rules that any other candidate would have to follow. In addition to providing informal advice about Chapter 68B and enforcing Chapter 68A with local government, we also have the discretion to enter into an agreement with local governments authorizing the board to enforce a code of ethics. We've never had anybody take us up on that offer. It's in our chapter. And it's silent on whether we can charge, but I envision that if a county or school district or city asks us to enforce their local code of ethics, that we would have some kind of mechanism to charge in the event that we had to investigate complaints or that sort of thing. Lastly, we also have the jurisdiction to investigate complaints regarding whether county redistricting plans were drawn for improper political purposes. The last redistricting timeline, we only had one complaint. It was about Polk County, and our board found that there was no evidence that the plan was drawn for improper political purposes, but the board did issue an opinion criticizing the current framework and encouraging the legislature to implement a plan similar to how our legislative districts are drawn, which the legislature has not taken up. And like I said, If we get complaints about local government officials and employees, we do not have jurisdiction to enforce those or to investigate those complaints, nor do we have jurisdiction to enforce Chapter 68B when it comes to local government officials and employees. 68B.34a says any complaint alleging a violation of Chapter 68B shall be filed with the county attorney. And if the county attorney has a professional or personal conflict, that complaint shall be referred to another county attorney. Code does not provide a lot of guidance for county attorneys in this respect. And I just had a nice conversation with the county attorney last week who had a couple of these and wasn't sure what to do about it. Chapter 68B lays out in great detail how the legislative ethics committees and how the ethics board is to handle complaints and what our authority is, what sanctions are available when we have subpoena power, what the standard is and reviewing these. And the chapter leaves a lot to be desired, in my opinion, as far as what a county attorney is supposed to do with these. A lot of times the county attorney, if it's a fairly minor violation, will just talk to the employee or official and advise them not to do it again. But I think this is another area that could definitely be improved in Chapter 68B. Okay, so the things that I get asked about the most, the first one is Iowa Code Section 68A.505. And that section says a government body shall not expend or permit the expenditure of public monies for political purposes, including expressly advocating the passage or defeat of a ballot issue. So we're going to break this down a little bit. So the first thing is, what is political purposes? Political purposes, I talk to a lot of people that think everything's political, and to some extent it is. But for our purposes, political purpose is expressly advocating for or against a clearly identified candidate or ballot issue. And then let's talk about the definition of express advocacy. I spend a lot of time talking to people about this definition. So this statute says, express advocacy is a communication advocating the election or defeat of one or more clearly identified candidates, or the passage or defeat of one or more clearly identified ballot issues. The communication uses explicit words that unambiguously indicate that the communication is recommending or supporting a particular outcome in an election with regard to any clearly identified candidate or ballot issue. So the two words I spend a lot of time thinking about are explicit and unambiguous. We consider ourselves a magic word state. We're really looking for vote for, support, that sort of thing. If you're merely talking about a candidate, merely talking about a ballot issue, that's not express advocacy. You are unambiguously recommending a particular outcome in an election with regard to any clearly identified candidate or ballot issue. This comes up a lot. We had a situation that was kind of interesting a couple years ago in a county where an elected official had an old poster from the 60s, and it said something about elect Democrats, I think is what it said, or it referred to the Democratic Party. Somebody filed a complaint. And for a couple of reasons, but one of them was that it was not referring to any clearly identified candidate or ballot issue. Now, in that case, we did suggest that the elected official move the poster to an area that was not available, it was not viewable by the public. It wasn't appropriate, but it didn't violate this provision. It also did not refer to candidates that were on the ballot. It referred to presidential candidate and some other folks for federal office from approximately 50 years ago. So anyway, this is a definition that we come back to time and time again. Okay, the same statute expressly says that it shall not be used to infringe on the First Amendment rights of government officials and employees. So how we read the statute is government officials and employees, for the most part, can be as politically active as they desire. They just can't expend public monies to do it. Now, there are a few positions in state government that are prohibited from engaging in political activity. We don't enforce those provisions throughout state law that refer to members of the Public Employment Relation Board, counsel for the Utilities Board. There's a few other positions. Director of Revenue is one. We don't enforce those, and I've never done the legal research if those are enforceable. Probably are. The Hatch Act at the federal level is somewhat restrictive and has been upheld, so those same statutes may or may not be upheld under similar grounds. But in any event, we don't enforce that. So from our standpoint, 68A 505 simply restricts the expenditure of public monies. We have an advisory opinion from 2004 where we opine that county auditors may be involved with a ballot issue or candidate campaign, even when they're overseeing the election where that outcome is decided. Now, that's a somewhat controversial issue, and we do get calls about county auditors and other members of local government who do get involved in campaigns, and we refer to this advisory opinion. The advisory opinion says we think it's a First Amendment issue, and we also think there's enough safeguards in place that would prevent an auditor from interfering with an election. Finally, the statute does allow a governing body to express an opinion on a ballot issue through the passage of a resolution or proclamation. All right, so let's talk about specific prohibitions. So we have administrative rules that provide more guidance on 68A 505, and I'm going to go through them. I also want to point out we had a court case a couple years ago where our rules were limited somewhat by the judge, and we've done our best to comply with that. So the judge reminded us that the statute says expenditure of public monies. Our rules really talk about the use of government resources generally. And in this court decision, a district judge reminded us that the statute says expenditure, so we really need to find an expenditure to find a violation. Oftentimes we can find that if the person's working, is doing something they shouldn't be on paid time, or using a resource that is causing an additional expenditure. All right, so keeping that in mind, our specific prohibitions in our administrative rules: you can't use government resources to solicit or accept campaign contributions. You can't use government resources to solicit votes, engage in campaign work, or poll workers on their preference for candidates or ballot issues. You can't use publicly owned vehicles to transport political materials, place campaign signs on publicly owned vehicles, or travel to a campaign-related event in a publicly owned vehicle. Now, I do get quite a few calls at the local level about this because we have quite a few government officials like sheriffs, but some other folks that have paid, they have the authority to use a government vehicle. In some cases, they're allowed to use it, including for their personal time. So I've spoken to sheriffs that say as long as they're in the state of Iowa, they're allowed to use their county-owned vehicle, whether they're going to the grocery store or their child's soccer game, or they're on the clock, so to speak. What we say here is you still cannot use that vehicle for public purposes. If they don't have another vehicle, for some reason have to use their government transportation, they need to reimburse their governing authority for the cost of that vehicle. We have an advisory opinion that we issued to Governor Branstad's legal counsel a number of years ago, because the governor, understandably, is always in a state patrol vehicle and is driven by a trooper. And so our advisory opinion explains basically the legal counsel provided us with a framework that they wanted to utilize as far as keeping track of political miles, and then they bill the governor's campaign on a monthly basis for those miles, and the campaign reimburses the state. And the governor's legal counsel asked us to sanction it, to agree to that course of conduct, which we did. So similar at the county level or city level, if there's a police chief that has a publicly owned vehicle and wants to campaign, same with cell phones, that sort of thing. They just need to keep track of them if they can't avoid them for political purposes and reimburse the government. All right, other things they can't do is use public resources to produce and distribute communications that expressly advocate for or against ballot issues or candidates. And we'll talk about this a little bit more in the context of ballot issues. And they also cannot use, they can't place campaign materials on public property, including the right-of-way. One thing I'll add is folks are very good at using public records requests in this respect, and there's it's frequent where maybe an opponent or a critic might do a public records request on emails of an official and ask for anything, maybe for a time frame or with certain keywords, and they're looking to see if the government email address has been used for political purposes, and that can create some problems. So we do have some school districts and cities and maybe counties, but I hear it more at the school level where the staff is reminded before an election that they need to be separating their political activity from their government responsibilities to avoid those kind of things. All right, permitted activity. This is our public forum exception. Any public resource that is open to a member of the general public to be used for other purposes may be used for political purposes. What I tell people that any resources that is open to the public, you just need to treat the politician or the political party the same way you would everybody else. So if there's a conference room in the library, or if there's a school cafeteria or what have you that's available for the public to use, if there's a charge for that, then you need to charge the candidate the same price. If it's free, then you don't need to charge, but you just make sure that you're treating everybody the same. Obviously, you can't give preference to one candidate or one party if it's a public resource. We also allow the public resources to be used for a candidate debate or forum, and our rule does allow for the distribution of campaign materials during that event. Just requires that at least 2 candidates are invited to attend. Finally, or additionally, a person may reimburse the government for the use of a public resource for political purpose as long as the resource was used for a public purpose or furthered a public interest. So a typical scenario would be, let's say it's a small community and a candidate's coming to town and there really is no other place for that candidate to have their event. They could use, maybe it's the school gymnasium or the auditorium, someplace that is not open to the public in general, but it could be used in that sort of scenario as long as the government is reimbursed for the actual cost of use. We do say in our rules that you may use public resources to produce and distribute communications that do not expressly advocate for or against candidates or ballot issues. Again, we're going to talk about that in a little more detail in a couple minutes. Public officials may wear clothing or political paraphernalia that expressly advocates while they're performing official duties. Now, I don't like this rule, I'll be honest. I think it's in poor taste if you're engaging the public and performing your official duties to also have a t-shirt on that says to vote for you or your boss, but our rules do allow it. It does say that the administrative head of that government could enact an internal policy that prohibits such conduct. So we don't see that too often, but I have gotten a couple calls over the years, and I think it makes people uncomfortable, to be honest with you, both the public as well as the people in the office. I remember talking to an individual that worked, I can't remember if it was an auditor's or recorder's office, something like that, and the recorder and the other staff were wearing a t-shirt that said, re-elect Megan or what have you. And this one person didn't want to wear the t-shirt. She said she didn't have a problem with her boss and she wanted her reelected, but she just thought it was inappropriate and she felt that it looked odd if she didn't wear the t-shirt. And I didn't have a great response for her because the rules do allow it, but I think you're putting people in an uncomfortable position if you're doing those sorts of things. Signs in the workplace, yeah, that's a good question. So we're going to talk about signs in a little bit. and they are generally prohibited on public property. The difficult thing is signs. Sign is not defined in our code. And there have been times when people have asked, is a t-shirt a sign or could it be a sign? If you chalk the sidewalk, is that a sign? Is a screensaver a sign? So it can be difficult where that line's drawn. There's a couple other provisions in the code that may address it, but a lot of these things, I think, kind of use your common sense. I talk to enough skeptics of government that don't have a lot of confidence in government, and I think this sort of thing does not promote confidence. And I really promote the idea that you keep your official duties and your campaign duties separate and apart, to both for the integrity of the office as well as for to make the public comfortable. When we're talking about using public resources to provide communications that do not expressly advocate, we do see some local governments, especially at the school level, where they'll want to put candidate profiles on their website or provide information like that. That is okay as long as they're not expressly advocating, as long as they're allowing any candidate to provide their profile. And it's just important that they keep those as neutral as possible. All right, another one that we get a ton of calls about, law enforcement. We have an advisory opinion that says law enforcement may campaign either live or with photographs in uniform unless the government has a policy that prohibits it. This is one of those things that people want to call me about a lot. Somebody sees an ad that, usually it's the sheriff, that they'll see an ad with the sheriff in his uniform and they think that's inappropriate, or it's a deputy or a police officer that's running for office and they're in their uniform. And I always refer them to this advisory opinion that says it's permissible. Where I think it gets kind of dicey is if you're campaigning live in uniform, the public naturally thinks if you're in uniform, you're on the clock. And our advisory opinion doesn't go so far to say that the government can pay you to campaign, but you can be in your uniform. And so I think it's just an issue of confusion when folks are campaigning in uniform. We do get that call on occasion. Candidate may be in uniform in a parade or at an event, and our advisory opinion does allow it. Another one we get a lot of calls about are job titles. And it's kind of funny to me because the public is comfortable with the governor and the president using his or her title to campaign, but at the local level, they just think it should be different. So this last city election, we had several mayors who wrote letters to constituents supporting certain city council candidates and referring to themselves as mayor, signing their letter as mayor. And we would get calls about that people thought that was inappropriate, that the mayor shouldn't be able to refer to him or herself as mayor and send campaign materials. We also get calls about deputy sheriffs in uniform with their titles in campaign ads for sheriffs and other folks running for election. So we always go back to this, that you don't have to hide who you are. You can refer to your job title and political material, whether you're referring to the candidate himself or somebody who's supporting that candidate. All right, so as promised, let's talk a little bit about ballot issues. This is where we get a lot of calls about. So again, express advocacy means unambiguously using explicit words to unambiguously recommend or support a particular outcome in a race with respect to any clearly identified candidate or ballot issue. So a ballot issue is defined as something that has been approved by the government to be on the ballot or is required to be on the ballot. So we have an advisory opinion that says before an issue is a ballot issue, governments can use their resources to promote it. Again, this is one of those things that's a little controversial. I think a lot of lay people would call that a technicality and they don't like it. So let me give you an example. We've had school districts that before it becomes a ballot issue will unambiguously tell people they need this new school or they need whatever the ballot issue is going to be about. They'll send emails to parents encouraging them to come into their school office and sign the petition so it can get on the ballot. And they can do that legally because it's not a ballot issue yet. I do tell people to be cautious here because in my 7 years at the Ethics Board, I've seen a lot of ballot issues kind of fail, and maybe they'd fail anyway, but I see that they go down when the public thinks the school district's being cute or being clever. And to me, if I were a school board attorney, I don't think I'd want to get started by sending emails telling people to come into the office to sign the petition, get criticized, and you haven't even started your ballot issue yet, and you already have people questioning your actions with respect to the ballot issue. So I encourage people, I say, hey, this advisory opinion does allow you to do it, but I'd be pretty careful here because I get enough calls about that sort of thing. There's also a Supreme Court decision that I reference in the materials that government entities can spend money to prepare for a ballot issue. Oftentimes, governments hire consultants, architects, all sorts of things to put a plan in place and then it goes on to become a ballot issue. And that Leonard versus the Iowa State Board of Education does permit that. All right, so that second bullet we've covered a couple times already, using government resources to produce and distribute communications that provide factual information on a ballot issue. In other words, are providing information that does not go to the level of express advocacy. Again, I tell people to be careful here because sometimes governments like to kind of appeal to people's emotions. While they're not engaging in express advocacy, it really upsets folks. It really upsets the public when a school district, for example, puts together some information and says a new high school would show that the community supports the school district, or could lead to economic expansion opportunities, that a new high school would encourage new business development or that sort of thing. I tell school districts, really stick to the facts here. When is the ballot issue? When is it going to be on the ballot? What is the language? What's going to happen? 60% vote is required to pass. You know, if it's a new school, when would you break ground? What does the school look like? Where are you going to break ground? When will the children be transferred to the new school? Other information that's factual, like changes in demographics or enrollment numbers or the age of the current buildings, that sort of thing that is factual information, not appealing to people's emotions. Our rules allow government entities and encourages government entities to allow us to review a communication before publication to ensure it does not contain express advocacy. That is not required, but it's just a service we provide. We are happy to do that, and I'm a cautious person, so if anything gets anywhere close to express advocacy, I will encourage the government entity involved to just dial it back a little bit. And I try to be real careful when I'm advising folks beyond what the law requires and make sure they understand. If I might tell them, I don't think that's express advocacy. I don't think it violates 68A, 505, but my experience is you might get a little pushback because of certain language, and you might be able to rephrase it just a little bit so that it's less controversial and less likely to cause a complaint. And like I said before, I've seen where this happens, where government might be kind of pushing the envelope a little bit. I've also seen where governments spend quite a bit of money providing factual information, glossy mailings, maybe radio ads, newspaper ads. Obviously, that's up to the government to determine what's appropriate. So these are materials that aren't telling people to vote, but just letting folks know about the ballot issue. People are real good at doing a public records request to find out how much the government has paid for all of those things. And the criticism is, well, if you have enough money to do all these flashy advertisements, then you probably don't need the money for a ballot issue. Now, of course, those are different pools of money, but again, those are the kind of things where you open yourself up to criticism, and then you're spending more time explaining and defending why your course of action is okay, rather than hopefully explaining what the ballot issue is about. So again, I'm more than happy to have those conversations, and I try to give people my humble opinion on how they can provide that information without generating a complaint or concern from the public. All right, nomination petitions. We get a fair number of calls about these. So in case you've never run for office or been involved in a campaign, a candidate for office has to file an affidavit of candidacy and a nomination petition. The petition has to have a certain number of individuals sign the petition, and that's based on what office you're seeking. So government officials have been known on occasion to either circulate that petition within their office or to leave it on their government counter for people to sign when they interact with their office. We have an advisory opinion we did a few years ago that said that it would be a violation of 68B.2A, which is our conflicts of interest statute. And that statute says you can't use a government resource for a personal purpose if that resource is not available to the public. And so our advisory opinion says a government official may not circulate his or her nomination petition in a government office or place that nomination petition on a government office counter if other candidates were not given the same opportunity. Now here's where it's tricky. We're talking about nomination petitions, so they're not officially candidates yet. So it's kind of hard to know. How do you, if you're, let's say you're the county auditor, how do you let your opponents or would-be opponents know they can circulate their petition just like you are, because they haven't filed yet, so you don't have a list of candidates. One place where I've seen this has been fairly successful, some counties have in their courthouse a place where they always allow petitions to be year after year. They have a little table, it's in the public area, they have a little sign, anybody can throw their petition there and get signed, and everybody knows about it, and it's kind of separate and apart from the government offices. I think if you're going to get into this, that's probably the best course of action, rather than if you're standing at the treasurer's counter and oh, you know, here's the nomination petition that you might want to be signing. Again, I think it just lessens the confidence people have that you're doing your job fair and impartially, and not with respect to politics. Okay, so campaign signs. I get a ton of calls about campaign signs, so I'd like to talk about those. I'm not going to get into all the nitty-gritty details because there's a lot, and I could probably talk for an hour just on campaign signs, and I don't want to do that. So just keep in mind it's technical, it's very complicated. This is why people hate government, and they hate people like me when they call and they say, you know, I was just trying to help. I was at the PTO meeting and I agreed to be in charge of the signs, and now you're telling me I have to create a campaign committee, and there's all these rules about where you can put signs, and it's hard. But anyway, these are the rules. We try to do the best we can to help people comply with them. We're not punitive when it comes to signs. If we find a sign in the wrong spot, we just ask you to remove it. As long as you do, that's kind of the end of it. All right, and we also get into kind of a ping pong match. I could use a different phrase, but I won't, where candidate calls us to complain about their opponent, and then the opponent, when we call the opponent and say, hey, we hear about your campaign signs, they say, oh, well, I wasn't going to say anything, but now that you're calling me, and we go back and forth, over and over about every little campaign sign. Again, I think you're kind of losing sight of what you're doing if you're the candidate, if you're spending all your time driving around looking at where your opponent's signs are. But nevertheless, you know, if we get those calls, we do try to enforce the statute. Unknown to probably some members of the public, we do not have sign police. We're not out driving around looking for these violations. If someone calls us, we will try to address it, but we're not looking for those problems. Okay, so our sign statute 68A.406. The first one, campaign signs cannot be placed on government property, including the right-of-way. We had an advisory opinion in 2016 that caused a little distress in a county attorney race. And in that case, the county attorney, the incumbent, had a very prominent sign on her car, large sign, and I can't remember if it was magnetic or maybe been even one of those shrinks signs where you can't take off very well. But anyway, she had a prominent sign on her on her vehicle for her campaign, and she parked it kind of in the parking lot, the government parking lot, but close to the road so everybody could see it. And she worked in this particular county. The county attorney is officed separate and apart from the courthouse. So her vehicle was on a typical day in the parking lot of her building or at the sheriff's office. And her opponent complained to us and said that's a violation of 68A 406 that says you can't have campaign signs on government property. We said in that opinion that she could have signs on her vehicle as long as it was not within 300 feet of a polling place and more than 90 square inches. And the way we resolved that is the statute says you can't have signs on government property. Then later on it says you can't have signs on vehicles within 300 feet of a polling place unless they're 90 square inches or smaller. And our board said, well, if we said that the first clause, no campaign signs on government property, was it, you wouldn't be able to traverse on a public roadway with a campaign sign. We have a lot of, whether it's schools, hospitals, lots of places where people come and go with their campaign signs on their vehicles. If we said that any government parking lot is prohibited, we thought it was too far and not what the sign statute intended. So we did issue that about 1.5 years ago. Legislature hasn't picked it up, so I think they're fine with it. But it did upset the opponent who strenuously objected to our advisory opinion. So anyway, that comes up a fair amount. You got to remember the 300-foot rule for our county incumbents. Many of them work at the courthouse. The courthouse is usually a satellite voting location, and so you have to be aware of that 300-foot rule, and we'll talk about that in a little bit more. All right, campaign signs may be placed on residential property regardless of the owner. So that's where it gets confusing, because I just said you can't have signs on government property, but you can have signs on residential property. So if there is residential property like a college dorm, you may have campaign signs as long as it's on the property that is actually occupied. So in the case of, say, a University of Iowa dorm room, you could have your campaign sign on the door or stuck in the window or on the wall inside the room, but you couldn't just stick it right in front of the entryway to the building. So residential signs, okay, but just be careful that it's restricted to where the resident lives. All right, campaign signs generally may not be placed on property owned, leased, or occupied by a bank, credit union, insurance company, or corporation. There are some exceptions to that. Ballot issue signs can be on corporate property as well as bank, credit union, and insurance company property. You can also have signs on your campaign headquarters, even if it's corporate property. And our sign statute also allows campaign signs on family farm corporation property. All right, no time restrictions on campaign signs. I still get quite a few calls, and we haven't had a sign statute for a long time that has time restrictions, but once upon a time we did. In the early 90s or mid 90s, the 8th Circuit ruled in a Missouri case that time restrictions on campaign signs was unconstitutional. And after that, we suspended enforcing those until the legislature was able to rescind that provision, and we haven't had anything since. I do hear on occasion cities that still have those, have ordinances that limit how many days a campaign sign can be up. Usually it's like 30 or 45 days before the election, has to be taken down 7 days after. I'd be surprised if they were ruled constitutional if challenged, but that's not up to me. So I always tell people that check with the city if you have a concern about the ordinance. The few that I have heard about, I've also heard that the city doesn't enforce, so they probably should just get them off the books. But anyway, at the state level, we don't have any time restrictions. All right, so let's talk about sign placement near polling places. You cannot have signs on the premises of any polling place within 300 or within 300 feet thereof unless it's private property that is not a polling place. Now that's important because I have heard from county auditors themselves, and I've heard from people complaining about county auditors that they tell people within 300 feet of a polling place that they have to take signs down even if it's their private property. And I reason I think the statute's designed that we shouldn't infringe on somebody's constitutional rights just because they're unfortunate enough to live near a polling place. I live in Johnston, and there's a very politically active property owner right next to City Hall where I used to vote, and he had all his signs right along the fence line, and that's perfectly legal under this statute. All right, also, kind of like I alluded to earlier, you cannot have signs on any motor vehicle or attachment if it is parked on public property within 300 feet of an outside door affording access to the polling place, and the sign is more than 90 square inches in size. So I think what we're trying to do here is say that within 300 feet of a polling place, we need to be careful. If it's a little bumper sticker, small sign, we're not going to worry about it. But if it's a large sign, they have to stay more than 300 feet away. At the local level, I know a lot of county officials where they get those magnetic signs and they'll drive around and they'll just, if they are at the courthouse and it's a polling day, they just take that sign down, or they park far enough away that they're outside of the 300 feet. All right, so how do we handle sign violations? Our sign statute refers to section 318.5. So that says government entities may remove signs after the board finds it's a violation, and in conformance, I can't remember the exact language, but basically pursuant to section 318.5, they can remove a sign. If you look at 318.5, you have to give advance notice to the owner of the property that's on government property. Then you have to assess them for the cost of removal. I've never seen anybody do that, to be honest with you. These are campaign signs. I talk to government entities that are kind of all over the board on this. Some cities and counties are very protective of their right-of-way and their property, and if there's a campaign sign, they're yanking it. Some of them will throw it away immediately. Some of them will keep it at the transportation garage for candidates to pick up. Some of them will be nice enough to call the candidate and say, hey, I just want you to know I got your sign. But a lot of them just pull it. Now, I also talk to government entities that say, we got better things to do than drive around looking for campaign signs, and unless it's in the way or causing some kind of problems, we're not going to do anything about it. And I also talk to some that say, well, we may or we may not, depending on the time and staffing and what's going on. I do tell people to be kind of careful here, especially if it's a city race and we're talking about city officials that may or may not remove signs. I'd say let's make sure you're consistent. Either you pull the signs or you don't, and you don't want to be accused of pulling the mayor's opponent signs, but letting the mayor's signs stand and that sort of thing. So I think it's fine to pull signs, but just being consistent is important. And I'll work with a government entity, because sometimes people send me these pictures. Well, I can't tell how many feet away it is from the road, so I might send the picture on to the county or the city and say, hey, this kind of looks like a right of way to me. Can you tell me if you agree? And oftentimes they help me out there. So anyway, that's kind of how we work on things. If it's a government jurisdiction where they're not going to pull the signs, we will take those calls. What we do is we call the candidate. It's typically candidate signs. We'll call the candidate and say, hey, we heard that you have signs somewhere where you're not supposed to. Can you go take a look? If they're there, can you pull them or move them further back so they're not in the right of way, whatever the case may be. Excuse me. And usually I ask if they can do it within 24 hours. Most candidates are more than happy to do that. And that's kind of the end of it. I have a lot of people when they're calling about campaign signs. With most things, when people are calling us, they don't really care about the campaign sign. They're annoyed with they don't like the candidate. They're trying to pick on the candidate, and that's fine. But and they want us to be more punitive. I've actually been asked to remove people from the ballot because of a campaign sign, or send them penalties. And I remind people kindly, hopefully, that candidates don't always know where their campaign signs are. You might hand them out at events. I've had candidates tell me how carefully they placed all the campaign signs to make sure they were behind the right of way, and then people mow or they move them around, and so that happens. And so we're not going to be real punitive here. Another thing that we keep in mind, something that is a real directive from our board, we don't want to create an impediment to people running for office. We don't want to be so annoying and so punitive that nobody wants to run. You know, a school board, city council, they're not getting paid, or they're getting paid very little to be in those positions. Many of these people are novices. They've never run for office. This is all kind of new to them. So we're really focused on compliance. And if we hear of an issue like a campaign sign violation, we're going to have a little conversation with the candidate, educate them on what the rules are, help them, and ask them to remove the sign if the case may be. And that's kind of where it ends. All right, so I got a few more minutes. I want to just touch briefly on the gift law, as well as if anybody in the audience is thinking about running for office, and then I'll take questions if there are any. So the gift law is in Iowa Code section 68B.22. And I'm not going to get into all the nuances of the gift law, but I just want to bring to your attention that the gift law applies to state and local government officials, employees, and candidates for office, as well as their immediate family members. So if someone's running for office, even if they aren't in government at the time, the gift law is still going to restrict what they can receive as gifts. The first exception to the gift law is campaign contributions. So you can accept campaign contributions even if from somebody that might have an interest in your official duties if you were to be elected. So the gift law basically says if you're a government official or employee or a candidate, you may not accept a gift from a restricted donor unless one of 19 exceptions to the gift law applies. So the first inquiry is it a restricted donor? Typically, restricted donors are people that have an interest in what you're doing and would be affected by your official duties in some way. And then if the answer to that question is yes, that the gift is coming from a restricted donor, then you have to look to the gift law and see if there's an exception that allows you to receive that gift. So again, the first exception is campaign contributions, and the gift law also allows, the one that everybody knows about is a non-monetary gift worth $3 or less, but there's some other ones in there as well. All right, so if you're thinking about running for office, I just want to give you a few tips. And the overall tip that I always tell people, if you're, I can talk to you, 18 months out, but you're not going to remember all these little tips. If you decide to run for office, just call our office and we'd be happy to help you through it and make sure that you get off on the right foot. There's a lot of good people that candidates rely on. Unfortunately, there are times when somebody that's helping them gives them bad advice. So I always think it's a good idea to go to the source. So give us a call and just say, hey, I'm running for mayor, I'm running for city council, I'm running for the legislature, whatever the case may be. And we'd be happy to get you started and make sure you understand what the rules are. So here they are, just briefly. If a candidate raises or spends more than $1,000, including the candidate's own funds, they have to register a candidate committee with our office and then file periodic disclosure reports. So once you file that initial statement of organization for the committee, you'll be kind of on our radar, and we will be sending you reminder notices about when those reports are due. We'll give you some information on how to file those reports, and then I call it the hamster wheel of reporting. You will have a continuing obligation to report periodically to us until you close that committee. All right, you must obtain the name and address of any contributor who gives more than $25. Sometimes folks will run for office and they'll have a little event and they'll put a pickle jar out and people stuff money in it, and then they later on find out about this rule. So just make sure you're getting names and addresses of anybody over 25 bucks. You may not use campaign funds for personal expenses or personal benefit. We don't allow you to take a salary or a stipend or anything from your campaign funds. Candidates, PACs, and parties may not accept contributions from banks, credit unions, corporations, or insurance companies. The one exception is ballot issue committees. Iowa does not have campaign contribution limits, although I know at least Iowa City does for their city elections. I don't know if there's any other jurisdictions that have a limit. Iowa City is the only one that I've ever heard about, and that would be enforced at the city level. You must also include an attribution statement. That's your paid for by on most campaign materials. Again, there's a whole slew of rules about that. When they're required, when is the exception, but just keep that in mind that most things need to say who paid for it. And then finally, my best advice to you is to find a good treasurer and keep an eye on your financial activities. We do talk to candidates where they weren't paying attention, and maybe everything's fine except the treasurer screwed up the report, and the report looks like you have a negative cash on hand of 2,000 bucks, or something that looks kind of silly. Or we've seen candidates not keep track of their treasurer. The treasurer reports late, and the candidate's embarrassed and didn't realize. So just keep an eye on what's going on. Find a good treasurer so that you can keep your finances together and avoid any other queries or complaints. That's our reports are on our website within an hour of filing, and the public, the media, and your opponent will always be looking at your reports, and they love to jump on those things. So having a treasurer that you trust that files a nice report will go a long way in promoting your competency for that office that you're seeking. All right, so with that in mind, it looks like I have about 6 minutes left. I'd be happy to take any questions anyone has.
I have a question.
Okay.
What are the most common problems you see?
Common problems. At the local level, we see people that didn't know they had to create a campaign committee. Sometimes it's because they thought if they only spent their own money, they didn't have to create it. Attribution statement violations is a common one. People send out materials and they don't put the paid for by on it. We also see at the local, most of our violations are at the local level. By the time you're running for the legislature statewide, most of those people have either some experience on their own right, or they have people with them that are pretty good that are helping them keep their campaigns pretty tight. But we also see corporate contributions. That's fairly frequent at the local level. I think most people understand there's a ban on corporate contributions, but they think when they hear corporation that means the big guys, like the Fortune 500 companies. They don't realize that their brother-in-law who wrote a check from his small business account is incorporated. Another thing is candidates sometimes own corporations, so they can't use their corporate copy machine to make copies, or their corporate-owned vehicle in the parade unless they reimburse their own corporation. So that feels kind of weird to them, but our statute says you can't take anything of value from a corporation. It does not distinguish between whether it's the candidate's own corporation or a small corporation or a large corporation. So those are the kind of things we see. Also, just ongoing, sometimes things are a little sloppy. People, there's a deadline and they kind of put something together that maybe doesn't have as much detail, and when we're auditing, we have to go back through and we spend more time talking to them about needing to put explanations and more detail on their report. They might not have done anything wrong, but they just need to put more detail in the reports.
You have a board that you work with. What types of cases go beyond the board that would go to district court?
Very rarely does anything go beyond the board. It's mostly let's see, we've had couple instances. Once we had a judicial review. That's the one with the definition of 68A.505. We reprimanded someone on a violation, and he sought further review. And like I said, the district court reminded us the statute said expenditure of public monies. Another time we had a situation that kind of surprised me, where some local candidates had taken campaign contributions that they shouldn't have. Small, one was a $25 corporate contribution, a couple other small violations, what I would consider small, and the county attorney filed criminal charges. If you knowingly and intentionally violate 68A, it's a misdemeanor, and the county attorney charged 3 candidates and a business owner, which I thought was overkill, and so did the 2 juries that heard those cases. Quickly found them not guilty, and then the other cases were dismissed, and the county attorney was primaried and lost. So I think that was unusual. So it does go beyond us once in a while. I guess also when I started, there was already a lawsuit challenging our independent expenditure statute, and the 8th Circuit found part of that was unconstitutional. So we were the first state to amend our law after Citizens United, and the 8th Circuit found that our ongoing reporting requirements were too burdensome. So we have now what we call event-driven reporting when it comes to independent expenditures. If you do an independent expenditure, you have to report. If you don't have any activity, there's no reporting.
Are there any campaign materials that don't require an attribution disclaimer?
Sure, there's quite a few. There are anything that the inclusion upon which would be impracticable. So those are your business cards, your pencils, your t-shirts, all sorts of things. We also exclude any an attribution statement if it isn't express advocacy. So if there is, and personally, I tell people, I've seen enough of this stuff that people don't read very carefully. So if you can engage in express advocacy, sometimes I'll see candidates do this. They'll be kind of subtle. They'll just say, give their background, but they won't actually tell people to vote for them. So if your communication does not include express advocacy, you don't have to have an attribution statement on it. But for the most part, you do. One big exception are live and automated telephone calls. For whatever reason, they don't have to have attribution statements. And if I've had a few where the automated phone call was kind of controversial, often it's about a ballot issue, and people are very upset. They're very offended by those calls, and then they're even more upset when they call me to complain that there wasn't an attribution statement when I tell them that Iowa law doesn't require it.
Last question. Why isn't the prohibition on corporate contributions abrogated by Citizens United?
That's a good question. So Citizens United simply said that corporations may independently spend money, that the FEC and federal law went too far by prohibiting corporations from acting independently to express their political views. There have been attempts to take that a step further. There's been some court cases that have taken the Citizens United and encouraged the courts to then strike down the bans on corporate contributions, but those have never gotten to the Supreme Court. There's been a few cases where a circuit court has said, the ban is legitimate for a number of reasons, mostly to maintain the integrity of the process and avoid bribery and that sort of thing. And the Supreme Court's never taken those cases up to, I think if they did take one, there'd be concern that that ban would be struck down. So we haven't seen it yet. And that is a question that I do get from more savvy candidates when we call them and say they can't accept a campaign contribution from a corporation. They say, well, what about Citizens United? So Citizens United is all about those independent expenditures. And that's why we're seeing more independent expenditures after Citizens United. Yeah, thank you very much.